All right, good morning again. Just by way of brief introduction, want to introduce Cassandra Johnson from the National Council of Juvenile and Family Court Judges. As you know, a number of years ago, we were deemed an implementation site within CJ, FCJ, and Cassandra is our consultant technical assistance provider for that project. So, Cassandra, welcome. Do you have anything you want to say?
No, just good morning. Thank you guys for having me here. We're looking forward to it. And I'm just here in support. So if anybody has any questions about the implementation site program, you can see me afterwards. But yeah, I'm just here to support our judge.
Thank you.
Thank you.
So I'd like to introduce Judge John Hudson. Judge Hudson was a youth court judge for 31 years in the state of Mississippi. Presided over child welfare and juvenile justice matters. At the time of his retirement, he was considered one of the most experienced juvenile court judges in Mississippi. And at that time, and still to this day, he was designated as the first jurist in residence for the state of Mississippi, and he continues to hold that position today. And he assists courts across the state of Mississippi in matters of child welfare. And he's been recognized as a leader in youth court reform. He's a judicial trainer, and today we're hearing about the art of making reasonable efforts, findings pursuant to, and also the Family First Protection Services Act. He has a number of awards. Bear with me. I'm going to tell you a number of them. He received the Lifetime Achievement Award by the Juvenile Justice Advisory Committee. He was one in 2015, received the Chief Justice's Award for contributions to the juvenile justice system. Received the Mississippi State Department of Education commendation for judicial leadership and improving access to education for at-risk children. Received the Mississippi Bar's Judicial Excellence Award, the Mississippi CASA Judge of the Year Award, the Looking to the Future Award from Mississippi Children's Services. And the following, I wanted to ask him about this, but maybe he'll give us a brief explanation. The Distinguished American Award by the Ms. Lou chapter of the National Football Foundation College Hall of Fame. So maybe he'll start with that. But also just ask you to take it easy on him today. Ole Miss lost to LSU over the weekend. And I'm a fan of anybody who plays LSU at this point, anybody who plays LSU because of Brian Kelly's departure from Notre Dame. So I was talking to John, and you know, they went up to a big lead, and unfortunately didn't hold true. But John, yeah, welcome and thank you for joining us today. Let's give it.
Thank you, guys. It's great to be with you. It's actually. I live in Southwest Mississippi, Natchez, Mississippi. You may have heard of it. It's the oldest town on the Mississippi River, 2 years older than New Orleans. Most of theirs are grim. And we have a very historic town, but unfortunately it's only 80 miles north of that dreaded place called LSU. And we have, throughout my life, I have been an Ole Miss fan and lived in the shadow of Tiger Stadium that they call Death Valley for all those years, and have pulled against them. I remember when I was a very young child, my dad we were Ole Miss fans, but Ole Miss, you understand, is 240 miles away from my house, 260 miles. LSU is 80 miles. And we would go to LSU games all the time. And we'd pull for whoever they were playing every time we went to those games. So anyway, that was a miserable day in Tiger Stadium on Saturday, I can tell you that. I would not wish that on anyone, that they have to go through that. But thank you for inviting me and being here. And like I said a moment ago, this is a bucket list kicker. I've never been to Delaware before, and now I can fill that in on my national map of the states that I've been to and been a part of, and certainly appreciate the hospitality that I feel that I have felt here. The Miss Lou Award that you were talking about just a minute ago, I don't know if you know much about the Hall of Fame of college football, but it's they give 2 awards out every year, one to a to an athlete, which I am not, and for all their contributions, and then one to a non-athlete for contributions that they have given. And the Miss Lou chapter is my hometown in Natchez, so that's what that was. And I was able to receive that award. It was very nice. But we're here to talk about reasonable efforts. So we're here to talk about the importance of reasonable efforts and why reasonable efforts are a key instrument tool that courts have, and why Congress decided that reasonable efforts was something that were important. And I don't know if does anybody here know when Congress first decided that? Anybody have an idea when? I hate to say this, but it was 1980, as you'll see a little bit later. So it's been about 42 years part of our jurisprudence. But I hate to have to tell you that much of the time that I was on the bench in Mississippi was during that period of time. I went on the bench actually right as this law was being passed, and I didn't pay much attention to it myself for about the first 15 years. And I hate to say that, but it was terrible. But I think that was true across the nation, that people just didn't pay attention to something that was so critically important. And as we get into this, we'll see how critically important it is. You may know or may have heard of a judge named Lynn Edwards. He has written a book on reasonable efforts, which we call the Bible of Reasonable Efforts. A new edition is out of that book. I'll pull it out of my briefcase over there. I brought it with me. So that,
My bad.
Oh,
no. Sorry. Sorry. Go back. Go back.
You go back.
Go back. Go back. There we go.
We're back.
It wasn't working before.
That's where we
Okay.
right there.
My bad.
Okay.
Sorry.
But he made a statement in that book, which is very, very true, and something we should remain that we should hold close to us as well, is that reasonable efforts and no reasonable efforts findings are the most powerful tools juvenile court judges have at their disposal in delinquency cases. And judges should pay special attention to them to ensure that the agency, and I understand we got some agency folks in the back there, that the agency is doing its job to make positive change in the child protection system, but most importantly, to improve the outcomes for children and families. He called it the most important tool. I kind of got ahead of myself. I do want to pause for just a moment, though. There's I don't know if many of you know this guy, but his name was Tim Jasko Fisher. I never get his first right name or last name right. But Tim was really the organizer, or one of the organizers of this whole series in developing the importance of the art of reasonable efforts findings. And over the last couple of years, I've gotten to know him, and he is a great guy and brought a lot of vigor and commitment to seeing that courts around our country really embraced this particular topic. And when I got off the plane yesterday and brought up my emails, my first email was from a person that was telling me sad news that he had tragically died. And he had an acute illness that really took him down in about 3 or 4 days. And so I just want to shout out a tribute to him today for all that he has done in this particular area, in the gifts that he has given us through his wonderful witness in to juvenile court judges, to the youth court system itself, to the juvenile court system itself, and to the importance of taking care of the kids. Okay. When we think about when we think about our job, we look at the general public, and the general public looks at us as, what do y'all do? What is it that you're about? This is what they usually think about, right? They think about, now, you guys are involved in a situation where you're dealing with mean old dads that are knocking the willies out of his kid on a regular basis. And you've got a mother who is cowering in the background, not doing anything to protect the child. But the fact of the matter is, that's not mostly what we deal with. This is what we deal with mostly. It's this child, this kid. He is the reality. 75% of all foster children that are in custody, 75% are there for neglect. 75%, not abuse. Look, only 4% are there for sexual abuse. And similarly, only 12% are there for physical abuse. So, we think about, we know that because we've been living that all of our life. The general public doesn't know that. And the whole idea of reasonable efforts, when we talk about reasonable efforts, is to address the needs of this kid and address the needs of him and his family. I know everyone here is familiar with ACEs, Adverse Childhood Experiences. We have been taught that, we've been living that. We know the impact that it has on children and on adults later that have had these experiences. It has to do with 10 questions that are aimed at measuring the impact of trauma on children. And they come from several different areas: emotional abuse. They ask certain questions that reflect this: physical abuse, where you often push, grab, slap, whatever; sexual abuse, and then neglect, questions about neglect, and then finally family stability. And they can take a child who has had those experiences, and they can rate, usually most of the children that are in foster care have had 4 or more traumatic experiences, ACEs experience. And let's see where it comes from. Okay, you see it has, interestingly enough, you would have never thought this, but it has impact on traumatic brain injury, ACEs. Not because they got hit in the head, but because of the trauma that they had to go through as a child. Depression, anxiety, suicide is much higher. Bad, dangerous activities they participate in, unintended pregnancies, STD, chronic disease, risky other behaviors, alcohol and drug abuse. And then there are opportunities for education and for occupation are much lower than those that are not involved with that. And this is how it all works. We see that we live in a world where the soil contributes to, or actually nourishes, the adverse experiences. And the soil that these folks live in are often identified by poverty, discrimination, lack of opportunity, poor housing, violence in their neighborhoods, even community disruption. That's all in the ground that fosters them. But as the trees grows, it manifests those adverse experiences that can range anywhere from domestic violence to mental illness to physical, emotional abuse, whatever it might be. And that is the tree of ACEs. And as you go through that process, we see that here is a report of what ACEs has done to some of our children and families. Look at this. I'm not going to do them all, but look at just a 1,200% greater likelihood of attempting suicide if you scored 4 or more on ACEs. 1,200%. 1,200%. Think about that. Greater. And if you go up to 6, it's 2,900% greater. Don't say an ACE doesn't have an impact on these children. And just go down the list. More likely to inject drugs. More likely to have sex before 15. More likely to have chronic obstructive pulmonary disease. And all the way down here at the bottom, look at this one. 51% of kids with ACEs scores of 4 or more will have behavioral problems in school. 51%. They say, well, it's not too bad. It is bad when you compare it to only 3% of kids with ACEs scores of 0. 51 with 4, 3 with 0. Okay? And this is the result. Youth in our foster care system, unfortunately, only 50% of them, less than 50% of them graduate from high school. Less than 3% of them go on to college, and less than 1% of them graduate from college. Huge impact. Look over there. There's 400,000 foster youth. Somehow we lost the map of the United States that was right up above that 400,000. But Delaware's still there.
It's there, you can barely see it. It's like really
You
light.
can see it barely.
It's there. It's like a really light color.
Okay, but y'all got 542 foster youth in Delaware right now, which for us in Mississippi, that's a great figure. In Mississippi, we've got about 3,800 kids in foster care. Of course, we've got a lot larger state, but still, we're not proud of that figure, and we're doing everything we can do to pull it down, even though I can tell you that since we've begun this process of reasonable efforts and emphasizing reasonable efforts by the department, we have dropped our foster care population by 60%. That's huge. So we're kind of proud of that figure, but not proud that we were ever that high. Okay, when we think of parents' rights and the whole idea of reasonable efforts, we have to think in the terms of the parent's constitutional right to parent their children. And we know that that right is founded not really in statutory law or constitutional law. We put it in there, but it's a right that pre-existed before all law existed. And it is a right, as it says down here, that pre-exists government, and one that we retain as a people separate and apart from any statute or constitution. So it's an important right. But let me say this time. I think that even though that is an important right, clearly, and it's something that we have to pay attention to, this is who we should pay most attention to. This guy. It's about looking at the whole process through his eyes. And look what he says. I am a person and have the same constitutional rights as grown-ups, and I have the right to have both my mommy and my daddy in my life. That's what reasonable efforts is all about. Doing everything we can do as an agency, as a court system, as everybody involved in the court system, to see to it, if it's possible, that this kid has his mommy and daddy. And so, of course, we know it might not be possible. Dangers, safety issues may cause it not to be possible, but we try our best. And if we can't give him a mommy and daddy, we give him the closest thing to a family that we can give him. Okay? All right. Foster care itself came under scrutiny in the 1970s. We had a foster care system that was in place. The idea back then was that, hey, you know, if we have these kids that are growing up in these horrible conditions and all we need to do is put them in a good home, in a good place, and they will thrive and they will be just as successful as any other kid that would be taken out of bad conditions and put into good conditions. Problem with that was it didn't work. It failed miserably. I remember before I even became involved in these processes way before. I remember as a child, back in my hometown, a couple of houses down from me was a family that maintained foster children in that family. And I developed a really good friend down there with a foster child that would come spend some time with us. And I found out in talking with him that he had been in the foster care system practically all his life. He was probably at that time, maybe 13, 14 years old. And he was already in his 14th placement at that time. Now, needless to say, we were good friends for about 3 months because that's about how long he stayed there. He was gone. This was what became known as foster care drift. You take a kid out, stick them in a foster home. If they disrupt that home, they move them to another home, and then they move them to another home, and then they move them to another home. Before you know it, they've already lived in their lifetime more places than they have and never lived in any one place for a year or more. Foster care drifted. It was a miserable failure. So Congress took it on, and they first took it on and because of that particular failure. And they concluded that there had to be a significant overhaul. So they first took it on by looking at the Child Abuse Prevention Act, and that was in 1974. And that was the first time that Congress tried to really get a hold of the whole abuse process in America and try to bring some sanity to the process. And during the 4 years from 1974 to 1980, they maintained some data to determine what their next step was. In the intervening time, an important piece of legislation came out, which was really related but unrelated to this process, and that was the Indian Child Welfare Act. And I know everyone here has been exposed to that. And it introduced for the first time the idea of active efforts. Reasonable efforts didn't exist at this time. And basically telling us, number one, you've got to find out if the kid has Indian ancestry or is eligible for Indian membership, tribe membership. And if they are, you need to get with that tribe and see if they want to have the jurisdiction of the case. But if they're not, even then, in our systems, we have to apply active efforts to maintain the Indian family, if at all possible. Well, that happened in 1978. But in 1980, Congress passed the Adoption Assistance and Child Welfare Act, which for the first time interjected the reasonable effort standard. And it was they required that courts make reasonable efforts to make sure that the department has made reasonable efforts to avoid removal of the children if possible. And that was when that first came into being in 1980. I took the bench in 1982. So, I've been living with it almost the entire time of its history. And, my orders had that line in it because the Department of Child Protection Services at that time, called the Department of Human Services, will come to you and say, Judge, you got to make sure this line is in the order. Why? We know why. So they could get their money at the end of the day. And so we would always make sure that line was in the order. Well, by 1997, that became pretty obvious. And Congress acted again. And in 1997, they passed the Adoption and Safe Families Act. And that was the legislation that required not only reasonable efforts to prevent removal, but it also added a new reasonable efforts requirement. And that new reasonable efforts requirement was reasonable efforts to reunify after removal takes place, and then reasonable efforts if reunification is not possible to complete a permanent plan. And that there be child-specific findings made by the court about those reasonable efforts, whatever those reasonable efforts were. And that was all codified into regulations in 2000, and we live under those regulations now. So that's kind of how we got to where we got to, okay? All right, here's what they say. We have to make reasonable efforts finding that the agency made reasonable efforts to maintain the family unit and prevent unnecessary removal. That's the first reasonable efforts finding. And it's got to be made within 60 days of the child's removal. That is one of the most unforgiving lines in the statute. Not 61, not 62, 60 days. I regularly, as in my job as a jurist in residence, have to review orders come out of our courts that are sent over to me by CPS to review, and where they have missed that day by 1 or 2 days and try to find a way to see if we can make the child eligible. Because the problem is, if they don't make that finding within those 60 days, that child, the agency cannot receive $40 for that child for the duration of that child's stay. for the duration. There's no way to cure it. It's just done. Now, why would you think that's so? Well, the point is that if you don't make reasonable efforts to prevent removal in that particular case, it can't be undone. If it can't be undone, then there needs to be, this is Congress, a substantial penalty for that. And maybe next time it will be done the right way. Okay. In all of this, though, the child's health and safety is paramount, but the judicial finding the agency failed to make reasonable efforts to prevent removal, and please hear this, does not mean the child goes home. I don't know if some states that is the law. I hope it's not the law here. It does not mean that. Now, a lot of practitioners think, well, I don't want to do that. I don't want to make that finding because that kid may go home to an unsafe home. That's not what it means at all. It does not mean that at all. The court still, but before the child can be removed, can be placed back home, the court has to find that there's no continuing reason for the child to remain in foster care, that instead of going at home would be contrary to his welfare, her welfare. Okay. And then the other kinds of reasonable efforts we talked about that has to be found is the agency must make reasonable efforts first to reunify if a child is removed, and they have to finalize if reunification is not possible, then they have to show to the court must find reasonable efforts by the department to finalize alternative permanency plans, and there are some of those alternative plans that are there. And that has to be done within 12 months of the foster care entry, and then every 12 months thereafter. In Mississippi, we have to do it every 6 months. And I suggest that a much shorter period of time is the more appropriate way to see to it that children are best cared for and that we don't stretch it out for 12 months. If the court does not make the finding, the agency will not receive the 4E funding. But the difference here is that on this finding, it can be cured. And if the court should at a subsequent hearing make the finding that the department has indeed completed reasonable efforts for reunification, or reasonable efforts to finalize the other permanent plan, then the money can start flowing again. Okay, and there it is. Documentation must be explicitly documented on a case-by-case basis, and so stated in the court order. Now, what does that mean? Explicitly documented. Well, it sounds to me like it means factually documented what it was, what the reasonable efforts were, and why the court found that they were reasonable. If they're not documented, this is the only way to cure these. If the reasonable efforts are not documented in the court order, for instance, if one of those cases that I check on a regular basis, and I see that there was a shelter hearing, and in that shelter hearing, the court didn't include in its order an actual finding of reasonable efforts, I can go back, and I have gone back, and we have recaptured some of those children in this way by going back and saying to the court, look, if you can present to us a transcript where you made that finding from the bench and it just didn't make it in your order, then that works. We can restore the funding for that purpose. Neither affidavits nor non-pro-tunc orders will be accepted. So somebody in the reasonable efforts period, 60-day period runs in September, and somebody in October puts out an order that predates September running of the 60 days, won't work. Will not accept the non-pro-tunc order. Interestingly enough, in my district, and I hope it's not true here, they have even not accepted non-pro-tunc orders that were issued within the 60 days because of this line that they will not be accepted. But we've made the argument, well, if they're made within the 60 days, they're timely. They're not outside the 60 days. And I think most areas in the country follow that particular line of reasoning. Hopefully ours will come around. And then no court orders referencing state law will be acceptable either. Okay, there is the preamble to the ASFA regulations. Again, they point out that it's an important safeguard against inappropriate agency action. And they made it clear, and we'll talk about this a little bit later, that they did not want it to become a mere pro forma exercise in paper shuffling to obtain federal funding. I have to confess that for a period of time I was on the bench, that's exactly what it had become. Just some paper shuffling to make sure that they got their monies. Okay. All right. We've already covered that. The court must make findings of whether the department has made reasonable efforts to finalize a permanent plan of the child. Okay, that's good. That's fine. So why should we make, after, that's the black letter law about it. So let's talk about the applicable law, how we apply that black letter law. Why should courts make meaningful, reasonable efforts finding? What is the purpose? Is it? Again?
Oh, there we go.
To fulfill another one of those onerous federal regulations. Is that why we do it? I'm afraid some courts might do it that reason. Is it to say, we call them child protection services. I know y'all have other initials for that here, but is it to save our CPS from losing 4E funds for foster care? Is that the reason? Is it to dot I's and cross T's to maintain some data compilations standard? Is that what our reasoning for it is? I don't think so. If not, then why? That guy again. That's what it's all about. But that guy right there. He is a guy, a foster child who has experienced at least 4 adverse childhood experiences, resulted in crippling trauma in his life. And look at this last one. One of those traumatic adverse childhood experiences is the removal. When no matter how well-intentioned we are, when we as a system remove a child from his parents, it is an adverse childhood experience. We can't get away from that. Sometimes we've got to do it. Sometimes we have to commit this trauma on a child to protect the child. But we have to understand from the depths of our own being that when we do it, it is trauma for that child. And so if we understand it from that perspective, then maybe we'll spend a little more time deciding whether or not we have to do it in the first place and holding people accountable to make sure they've done everything to prevent this from happening to that particular child family. We know children want to be in their own homes, no matter how abusive or neglectful it's been. That's what they want. But we can't be guided by that, but we need to know that. We know they perform better when they're safely with their family. They're gonna do better. Those percentages we talked about earlier, those percentages are gonna increase tremendously when they're at home with their own family. Okay? So, reasonable efforts has 3 overarching goals. Number 1, go 1. Get ahead of me.
Oh, sorry.
Keep families together. That's the first one. And then if you can't keep the family together, if you can't prevent the removal, to reunite the family when they have to be separated. And when that's not possible, to achieve an alternate plan for permanency for the child when they can't go home. We don't want kids involved in foster care drift, period. That's got to be stopped either here, or here, but it's got to be stopped. Kids have got to be at a permanent home where they can live out their majority. And there they are. There's that quote again. Reasonable efforts finding is the most effective tools that judges have to monitor whether the agency is doing its job. Prosecutors, if there are any prosecutors here, are to ask those tough questions, but if they don't, the law expects an inquiring jurist to be involved in that process as well. And to ask the tough questions about whether or not those reasonable efforts have been met. And then that last quote kind of hits me right in the gut for the first 15 years of me being on the bench. For the court to ignore the reasonable efforts issue is to abrogate judicial responsibility, simply conclude without any analysis that the agency is doing its job well. For the first time in 40 years, the Children's Bureau is on board on this. They've been pressing very hard for courts to use this tool to make sure that these efforts are being done and are being done consistently. They want more specificity in the court records about reasonable effort findings, and they want it to be a meaningful exercise, not just a pro forma exercise. 2 years ago, I had I won't say what state it was, but I had the opportunity to go do some assessments of courts in another state. And I sat in this one particular courtroom that had permanency hearings and review hearings going on all day long, on about a 15-minute per case hearing. Think about that. And every single one of them, the judge would say at the very end, and we make our ordinary reasonable efforts findings. Every single one of them, that was the reasonable efforts finding in that case. The Children's Bureau say it no more. That's not what the law intends. It intends a much more robust approach to this process. Okay, so we've hit some of the learning objectives already. We understand the legal requirements placed on the child welfare agencies. We understand the court's oversight responsibilities. We understand what happens if this doesn't happen. And now we're at determining how do we identify what is a reasonable effort and what is not. And that process has got to be difficult. That was the whole purpose of the reasonable efforts legislation in the first place. It's got to be difficult. It cannot be lightly considered. It should be difficult to remove a 5-day child from its parents. It shouldn't be an easy process to happen. The requirement of reasonable efforts to prevent removal intentionally makes it difficult. Intentionally. The requirement to reunify intentionally presses the agency to move in that direction immediately. The requirement to accomplish permanency when reunification is impossible imposes upon the agency an urgency to get this done. Not to sit on your hands, not to wait, not to stretch it out, to get it done so this kid has a permanent place. But the truth of the matter is, it will only be difficult if the people that are a part of the system are committed to making it difficult. That's the only way it'll be difficult, or it will fall right back to where it was pre-ESPA. So, what's the objective? To ensure that every child that should be in care is in care. That's the dangerous situation, but not a single child more. And to ensure that every child that is in care is in a safe, nurturing placement that is supportive of a permanency plan for that child. That's the purpose, that's the objectives of reasonable efforts. So, court's role. The court holding a child welfare agency accountable for making reasonable or active efforts is not just a best practice, which has been called for many years. It's the law. It's the law. We have that responsibility. I plugged in a couple of other slides that really don't apply to reasonable efforts, but I think it's important in this discussion. We know that when a child is removed from the home, that the very first ruling that the court must make, in that very first ruling, the court has to make a contrary to the welfare determination. And that's just like the reasonable efforts to prevent removal. If the court doesn't make that finding in the very first order, then the department loses their foster care funds for the life of the case. Pretty tough. But again, the purpose behind this is to make sure that the judge, when you get that midnight call, is asking the questions: do I really have to do this? Do I really have to move this child? Is that what for certain that I have to do? Is it contrary to the welfare? And ask the question of the social worker who's at the site. Is it contrary to the welfare of this child? What are the dangers? Articulate them. Tell me what are the dangers if I leave that child at home? Is there anyone else that can be brought into that home that will mitigate those damages, those dangers? Those are the determinations that the court needs to be asking about to determine whether it is indeed contrary to the welfare of the child to be moved in the first place. And they sound a lot like reasonable efforts to prevent removal, but they're not. There's a difference, and the difference here is the immediacy of the situation. Is this child safe? If he's not safe, is there a way we can make him safe absent removal? And then if that's not possible, then removal, okay? And then we talked about the Indian Child Welfare Act. I just put the provisions in there for you. We've already covered those, but that is key. May I suggest at this point that, we talk about reasonable efforts, but perhaps we ought to be thinking about active efforts, at least at the very beginning of cases. And maybe we can move those cases back to reunification. All right. These are I tried to find in your law, your thresholds, and I know you know where they are. I didn't know where they were. So I'm giving you my thresholds with our thresholds in Mississippi. Before a child can remove, that has to be an immediate or significant risk of harm. Y'all are probably very similar to that. Or there can't be a parent or custodian who can provide for the necessary care, custody, and supervision of the child, and that there's no alternative to custody, no one else for the child to go to that's in the best interest of the child. And finally, the federal law adds contrary to the child's welfare. So that's a threshold for removal. But behind that threshold for the removal is all the questions that have to be asked about, okay, is there a danger of a significant risk of harm? Yeah, maybe there is, but is there something we can do to mitigate that without removing the child? That's what reasonable efforts is about, okay? We know the consequences. We've already talked that to death already. 60 days and you lose somebody. So where do you do it? Where do you make these findings? Y'all have a preliminary protective hearing within 10 days, I believe it is, of the removal. My suggestion, of course, is that you make the findings right there at the preliminary protective hearing. In fact, your rules actually say, and I can read it to you exactly, the court says, shall make a written determination within 60 days from the date of the child is removed from the home, whether reasonable efforts were made to maintain the family unit and prevent the unnecessary removal of the child from his or her home. So it just says you got to do it in 60 days, which is the federal law. Well, my suggestion is that you do it at that first hearing, that protective hearing. One of the reasons why, at least in our state, one of the problems that occurs is that in our state, we call it shelter hearing. We got to do ours in 48 hours. But if we don't do it at the shelter hearing, it often gets lost in here because you end up running into a situation where, well, we don't have the right address for the parent and we've got to continue this adjudication so we can get the parents before the court. And when you finally get the parents before the court, 60 days have passed. And you can't recover that. You can't cure that. So if you make it at that first hearing, that first preliminary protective hearing, then you cover that situation. If you don't, you need to have some process in place that somebody notifies the court before that 60 days run. You've got to convene a hearing, no matter where you are as far as process on the parents, or you're going to lose that. You're going to lose that opportunity. Now, fact of the matter is, when you do that hearing, you may find that they did not make reasonable efforts to prevent removal. I mean, that may be what your hearing says, but hopefully, more than likely, you will find that they did make reasonable efforts to prevent removal because they did indeed do those things. But unless you make that finding, then there's a loss to the agency of those funds.
Hey, John.
Oh.
Question, I'm sorry. So one of the things that, as a practical matter, I've asked this question before, when you're making a determination of the preliminary protective hearing. sometimes service is not affected. You don't have the parents coming to that first hearing. You don't have their ability to offer contrary evidence to what the prosecution, if you will, child welfare agency, is presenting. And of course, you've indicated there has to be some judicial activism, right?
Right.
You have to ask the questions, but can you speak to that a little bit? Because it seems to me that, parent attorneys also, if they don't have their client available at that first hearing for whatever reason, and they're losing an opportunity, I think, to present the evidence that maybe will inform us a little bit better on a reasonable evidence.
I agree 100% with that. And in Mississippi, we have told our people that if you don't make it at that first hearing, that you're probably going to lose it because of the service of process issues later on. So make the determination, but at any time allow a party to come back in and challenge that determination. And if the party comes back in 20 days later, 30 days later, and challenges that, once you get the process in that situation, then that is certainly permissible. And I think that is good. Unfortunately, the data shows that not too many, even parents' attorneys, are too interested in this at this point, and they should be. They should be interested in whether or not reasonable efforts are being provided in the case, and to prevent removal. And maybe it won't help your particular case if you raise that issue because the agency is going to lose that money anyway. There's nothing that can be done about that if you don't raise that issue. But if you raise the issue and have the court make a no reasonable efforts finding, if that's what the evidence will reflect in that case, I can promise you it will have a huge impact on the system as a whole. And it will bring about more effective advocacy for children, but more effective results for the court. The court will have all the information it can get to make that determination. And you are the ones that can produce, the parents' attorneys are the ones that can produce that information, but it's also the responsibility of guardian litigants in the case too, that if those reasonable efforts have not been made, what's the guardian litigant's responsibility? To act in the best interest of the child. Well, I can tell you right now, we have determined that it's the best interest of the child to stay at home if he can stay at home. So shouldn't it be the guardian litigant's responsibility to also see to it that these reasonable efforts are being taken, are being done in these situations? But that's how we do it in Mississippi. We allow it to be revisited. The problem is, like I said before, the 60 days that's an unforgiving deadline. And many times in our state, we've not even gotten the due process taken care of in a case before that 60 days is up in that situation, unfortunately. And so you got to make the finding, but it should be a finding that could be altered later on. Okay. It should be made, as I said, a preliminary protection hearing, and the court order should provide child-specific facts supporting the reason why the child was removed in that case. Okay. All right. I enjoyed reading y'all's rule on this particular case because you have some things detailed in your rules that I've been around to several other states that have nowhere close to this kind of verbiage in their rules, and I think that's good. In addition to that 60-day one that I just got through talking about, at that preliminary protective hearing, you have to make a finding that the department has used reasonable efforts to keep siblings together. I mean, surely we know that that's the practice, but there's not very many places that have put that into the rule. This is what you got to make at this particular hearing. And then at every regular scheduled hearing, you have to make the DSCFCYF has used reasonable efforts to effect safe reunification and to provide frequent visitation and interaction. We know that's best practice. We know that's what should be happening, but you guys make it happen. You guys said, hey, look, this is what you've got to do at these every hearing. You've got to consider safe reunification, and you've got to consider whether or not visitation in that particular case is appropriate case. And then at permanency, you have to make that reasonable reference finding the permanency plan within 12 months of the entry into foster care, which is the federal law, and then any 12 months thereafter, and then you have your definition of entry into foster care. I guess I read that and I read that and I read that, and I finally came to the conclusion that I can live with that. I have a little bit of a problem. The federal law, I think, allows this, but it appears that that definition of entry into foster care gives you 60 more days at least. And I have a bit of a problem with that because the federal law says subject to an adjudication or and disposition hearing, which I'm sure that's taken from. This is from the adjudication and disposition hearing. So when a child is taken in protective custody and a determination is made at that preliminary protective hearing that he should be held, are they not subject to an adjudication disposition hearing at that time? It's a question I just can't throw out. I asked Lynn Edwards about that, and he was a little perplexed as well. And but that's your rules right now, so I guess it's working for you, and I hope that it won't be contested in some future. Okay, what was Congress's intent? Here we are again. Number one was to prevent unnecessary removals. Number two, safeguard against inappropriate action. Number three, not to become a mere pro forma exercise. And then number four, an expectation of a true litigated hearing where the court receives evidence of meaningful, reasonable efforts. Okay. That was the expectation of those things. So, what judicial oversight is not? I'll read this to you because it's kind of hard to read here.
Yeah.
27.27% of judges have said in this recent survey that they only 27.27% have found reasonable efforts when evidence, excuse me, we start all over again. 27.27%, listen to this, have found reasonable efforts when evidence did not support that finding. Almost 30% of judges said that. The pro forma exercise. 89% reported having not made or seldom made a no reasonable efforts finding in the last year. Almost 90%. And then the most common reason where there was a no reasonable efforts finding was made in a reunification case, not a removal case. And we know why that's so too, right? Next. And here's some of the things that judges say, the reasons why they don't make those findings. I don't want to cost the state money. 51.61%. How many judges I have in the room? Us, judges. Is it our responsibility to decide whether or not the state gets money or not? Is that what we're supposed to be doing? Or are we supposed to be listening to the facts and determining the case from the facts? But 51% say they don't make a no reasonable efforts finding because they don't want to cost the state money. The state is one of the parties, and the family is one of the parties. The second one's even more perplexing. There was insufficient information for me to make a finding. Seems to me if there's insufficient evidence to make a finding of reasonable efforts, that means it's a no reasonable effort. That's what it seems to be, but that's what they do. Some say social workers are the experts. I respect their expertise. Who am I to argue with that social worker? I don't know enough to make a judgment about reasonable efforts. Well, thank you guys, you're here. We're here, that's one of the reasons why we're doing these, that we won't use that as an excuse. And this one I heard pretty recently. I don't want to crush the spirit of a new social worker. I'm not going to make a finding that the Congress expects us to make because we don't want to crush the spirit of a new social worker. Even more concerning, I need to protect our CPS and not lose services. I asked that judge when he said it. I'm a little concerned about the terminology of our CPS in a contested case. Is it not supposed to be the CPS instead of our CPS? And then there's no specific definition of reasonable efforts, and that's true, but I don't believe that is a reason to do that. So why are we to ensure reasonable efforts? Here we go again. To represent what the agency recommends? That's what a lot of courts did for many, many years. Now, it's to ensure the agency is doing what it's supposed to be doing for our children and its families. To improve the outcomes for individual families and children, to create every opportunity for them to live a vibrant, hope-filled life. That's what reasonable efforts is about. And then to improve the system itself. Not only that family, but to improve the system itself at every opportunity by raising expectations to provide resources to meet the needs of these people that are right in front of you and then the community as a whole. Again, on that last one, well, I'll talk about those. So where do you draw the line? It's just like courts all the time have to draw the line of whether or not they believe a parent is in such a shape that removal is necessary. Well, we also have to draw the line as to the department. Did they do what's reasonable? Let me tell you, y'all, your rules talk a whole lot about reasonable efforts to do this and reasonable efforts to do that. But I did not find a definition of reasonable efforts anywhere. And I think that's kind of intentional. What is reasonable? We're supposed to know as jurists what reasonable is and what reasonable is not. And it's our responsibility to draw that line. So that's a book, by the way, and by Lynn Edwards. If you don't have it, let me suggest that you get it. It's a great book to have in your libraries. And he has included all 50 states in the rules and laws in all 50 states. And he has it's about 300 pages long on just reasonable efforts. He has included cases from across the country on reasonable efforts. There was no definition under the federal law or regulation. There was an intent that these be handled on a case-by-case basis, not a cookie-cutter basis, but a case-by-case basis. Before removal, what did the agency do to prevent that removal and meet that federal standard? I didn't find a Delaware definition. Is there a statutory definition of Delaware? I didn't find one. Okay. Assume everyone understands the reasonable threshold. I did find some case law that says it is clear that some affirmative services must be provided. So that is some case law in your jurisdiction. It's a term of art. There's not a fast and firm definition. It is the reasonable provision of services by a social worker that the law requires, depending on the problem and the resources within the community. So, what is the
Measure.
Yeah.
Yeah, go back. Yeah.
There we
Okay.
go. There we go. Okay. Remember again, those are the three purposes: to prevent placement in the first place, to reunify family, secondly, if placement's happened, and then to achieve a timely permanency in the event that has not worked.
Can I ask you a question on something? Yes.
Sure.
You said within resources within the community. If the determination is made that the child who's in care requires particular services, and the response is, well, we put a request out to the agencies, the private agencies that provide those, and there's a 3-month waiting list. It strikes me that having this child suffer and not get the services they need is not the response because there's no services currently being contracted. So the issue of balancing need of the child versus the availability of resources is really a false comparison.
And I think I'm gonna get to that in just a moment when I talk about, there's really two tiers of determining reasonable efforts. The first tier are looking at that particular family and what resources are available. The second tier, is it reasonable if the resources aren't available? And I think that's part of the reasonable efforts finding process. I can tell you, a friend of mine also that I've been on this tour with from time to time tells of a story, her own story, of a judge in Nome, Alaska. Do you know where Nome, Alaska is? It's the northernmost actual community in Alaska that have judges and courts and stuff like that, but it's not very large. And they had a tremendous problem with drugs and alcohol in Nome, Alaska. And a lot of families were being blown apart because of that. And they would come to court, and in court, they would be told, they would make the agency would make its recommendations in court, and its recommendations was, so we want to do this, we want to do that, but he really needs DNA services, but there are no services. We have to fly him to Anchorage, and we just can't afford to fly him to Anchorage. And this judge heard that and accepted that for a few months while he was on the bench. And then he said, excuse my language, hell no. Said, if a person in Anchorage has that resource, why doesn't a person in Nome, whatever, Alaska have that resource? So he made an unreasonable efforts finding. And guess what? They have those resources in Nome, Alaska now. Because the judge made it with no reasonable efforts, that it was not reasonable that the services were available somewhere else and weren't available here. I call that justice by geography. Mississippi has a lot of justice by geography. And I was on the bench in a fairly rural area of the state. And I just didn't, no, that's not reasonable. If they could have it in Jackson, Mississippi, not to speak much of Jackson, Mississippi right now, but if they could have it there, then they could have it in Athens, Mississippi. Find a way. It's the reasonable thing to do. Find a way to get that done. So I agree with you. I think that I'm actually sitting part-time on the bench in Hinds County, which is Jackson, Mississippi right now. And I had one situation arise when we were trying to move a child toward adoption. I terminated parental rights in the case. And the only thing that was keeping us from the adoption, here the kid is waiting to be adopted. The adoptive family is right there ready for the adoption to take place. And I always do a review 60 days after to find out where we are on the adoption after the TPR. And they came and said, well, Judge, we can't do the adoption because our agency requirements requires us to do a psychological before we complete the adoption. This is in Hinds County, the largest county in Mississippi. And I said, okay, when are you gonna get that done? He says, well, we've got an appointment for it. I said, okay, when's the appointment? 3 months later was the appointment. I said, sorry, that's not reasonable. Well, that's who we contract with. That's all the person. So you live in the capital city of Mississippi. You're telling me there's another person in this city you can take that child to get that psychological. It's not reasonable. And they changed their policies that time so that could happen. That's the power behind that particular finding. That's the power the court has to make a difference in these cases. Exactly what you're talking about. Yes.
So what if it is reasonable? What if there is a 3-month wait for that service across the state? That's what we're experiencing right now. So I'm looking at the judges and I'm really worried that we're not making appropriate family intervention and for in-home support review. When we are experiencing all-time high staffing problems with our contracted agents. So could you address that just a little bit?
I will. again, it comes into it comes down to an assessment of reasonableness in that situation. Your contracted agency, what does that mean? That's a question that I would go into. Are there any other alternatives for the department to pursue other services in that area? Because the problem here is this. The law has given us 15 months to finish this process. And it had put a 3-month hold on that process for the families that are waiting to get the services that we say we're going to give them. And if that situation exists, what is the department doing to alleviate that situation? Are they doing anything? And if they are, I think that's part of the evidence that you put forward. What we are doing to try to alleviate this is this, but simply saying, hey, we made contract with this company and they can't get to it until 3 months from now, I don't think that's reasonable. But we worked with this company and they got so far behind, we started reaching out to other possibilities. And we're still working on that, Judge. That's where reasonableness comes in that situation. You just show that the efforts are being made to mitigate those problems, those issues that are there. But you just can't rely on the fact that, hey, we've got a contract and this is the way it is, Judge. Okay. All right. We know that there's some reasonable efforts can be, I'm not going to go into this, can be basically bypassed through those circumstances. Okay. The aspirational definition of reasonable efforts is what I call the golden rule. Now, most of the time you can read that. It's yellow instead of golden, so I guess that's part of the problem here. But it says, doing for children and families we serve that which we would want others to do for us and our families if we found ourselves in the same situation. Well, think about that. This is what it ought to be. The aspiration definition of reasonable efforts is doing for children and families we serve that which we want others to do for us and our families if they were found in similar circumstances. Oh. Okay. Factors to consider in making a reasonable efforts finding. You can see there first, the dangers to the child. You've got to make those considerations. The family problems that precipitated those dangers, that's at the very top. What services were available from the agency? What services did the agency give in that situation relating to the family's problems and the family's need? Whether the case managers in the case or the workers in the case diligently arranged services for the family? Whether the appropriate services for the family were available, talked about that, and timely available, and the results of those services provided. And then, are they realistic under the circumstances? You guys are a little bit better situation than we are in Mississippi in that your geographical area is more compact, and hopefully what services are available are pretty available across the board. I might be wrong on that statement, but certainly more so than in our state. But even then, we've got to make sure that those services are adequate and appropriate. Now, a lot of times in the past, when plans were put together and things of that sort were happening, a lot of the things that were in those plans had absolutely nothing to do with the reason why the child was removed in the first place. That's the appropriateness of those particular items, and then realistic under the circumstances. Family reunification services are not reasonable if they consist of nothing more than handing the client a list of services and putting the entire responsibility on the client to find and complete those services. That's not reasonable, period. All right, this is what I really want to get to. There's really two different reasonable efforts issues for court determination. Two tiers. The first one is, did the social worker provide the adequate services in a timely fashion to the client? The first one requires specific court findings tailored to the specific child in that case and the specific circumstance, and then the provision of what services were available there. That's the first one. But the second tier is were the necessary services available in the community? Okay, that's again where the courts should get involved. The second calls the court to be proactive in its community to press for the provision of necessary services to meet the needs of these families. Calls for the court to be proactive. We're different than any other judge is anywhere else. We're called to be proactive in caring for the needs of these kids because we're charged with acting in their best interest. That is our charge. Yes.
I just have a quick question about client.
About which?
Client, the parent, client. You're referring to the word client, you said it the last time.
The client is the parent and the child. A lot of times we forget the child is a client. The child is a client. We owe our responsibility to the child. Remember the little dude a while ago and his constitutional rights? Basic responsibilities. Okay, this is the first reasonable efforts. What are some things you look for to see whether or not reasonable efforts have been made? You look to housing. Studies have revealed some 30% could remain in the home if there was some type of mitigating service added to that case. You know, and we have some county collaboratives that are going on right now where the faith community has been co-opted, and that faith community has a network of folks. They have electricians and carpenters and all plumbers and all sorts of folks like that that are willing to give their time. If CPS calls and says, hey, we're gonna have to remove this kid from this home unless we can do something about this exposed electrical socket, or unless we can fix this porch that's rotten and falling in. And they will get the call and they'll go out there and fix it right then. Child's not removed. And if the child has to be removed, can he be removed with the parents somewhere until that can be mitigated and fixed? Again, lessening the trauma of those removals. Poverty, Lord knows, in Mississippi, we have it under the law that you can't remove a child because of poverty. But unfortunately, we turn around and do it all the time. Not intentionally, but we do it because we don't make provision for families that are suffering from poverty. And we've got to do that. Did the agency provide assistance to meet the needs? Did they mitigate the poverty circumstances? What are some possible areas of assistance? Childcare, homemaking, financial assistance. Long list there. Visitation, essential, absolutely essential. If we're gonna bring families together, we've got to provide reasonable visitation, and reasonable visitation is not twice a month. That's what it generally was in Mississippi. Yeah, Judge, we provided for reasonable visitation twice a month. No matter the age of the child, no matter if the child was 1 year old. That's not reasonable. You've got to do better than that. You've got to make it better than that. Okay, and that gives you several circumstances that will help you in that area. And did it fulfill the case plan? Did the case plan actually relate to the issues causing the dependency? And we do realize that reasonable efforts does not mean every effort. It means those efforts that are reasonable. Okay. Substance abuse, another huge area. 50 to 90% of dependency cases involve this factor, and I would probably shake your head on that. That's a huge factor in this situation. Domestic violence, another big area where children are removed in many circumstances. I'll give you a laundry list of questions that can be asked there. And that's domestic violence. It goes on some more. And some of the things when you think about domestic violence, it goes on. So often when domestic violence happens in a case, we sit there and say, okay, we've got to find a place for the parent and the child to go to get away from that abuser. Why? Why not remove the abuser, even if it is his house? Again, less trauma for the child. Move the abuser out. And then work with the abuser. And then maybe they could come back together as a family later. But the family home remains for the child. mental health issues. Is there a nexus between the illness, the mental health illness, and the risk to the child? Is that nexus there? Same goes with drug abuse as well. Is there a nexus between the abuse or the neglect and the use? That nexus has got to be there. Culturally competent services. What about when the efforts don't, this for a court to consider, when the efforts don't meet good faith? They provided a plan, yeah, a great plan, all these things they're going to do, but they didn't monitor anything. They didn't assist the family. Is that good faith? Okay. All right. So, again, addressing that first tier of reasonable efforts. When you look at the social worker, did the social worker assess the family situation? Was that something that the social worker did? Did they do a good job at that? Did they determine if any available services will work? Were they out there? Were there services that they saw would work? How about the father's family? Was that person accessed? I know, probably for my first 20 years on the bench, seldom the social worker ever mentioned a father when they came in the room. The situation, they were just kind of, deadbeat dad, they're not paying any attention to anything. But now we know that fathers are coming up to the plate, hitting the ball. So let's get them involved when those assessments are made. What about fictive kid? Is there somebody close to the family that would be willing to come in and work with that family and help that family in these situations? What are the alternatives to removal? Can an aunt, uncle, sister, brother, mother, father be brought into the home for a period of time to prevent that removal? Remember, what we're trying to do is get to the next meeting, the next hearing. We're not trying to solve the whole case at this point. We're trying to avoid the trauma to the kid by being removed. And if we can fix it so we can get to the next hearing without removing, then we've accomplished it until that next hearing. And then it becomes our responsibility that next hearing to get to the next hearing. And gradually, if we do it that way, we will all ultimately find the ultimate answer, yes.
Unless children are taken up to being bred into the division, we don't have to. So, I was a little confused.
I'm talking about removal here.
Okay.
We're assuming there was a removal here. Because reasonable reference has to do with children in foster care. And you making reasonable efforts to prevent removal, then making reasonable efforts to reunify, then making reasonable efforts for permanency later on. Okay, that's all reasonable efforts has nothing to do with children that are not in foster care.
We have a whole range of people in units that are working to keep kids from coming in here.
And that's part of reasonable efforts to prevent removal. That's prevention services, and that's great. And that's what needs to be going on. That's what needs to be going on. I do want to, you raise an aside that I want to bring up at this point too. And I don't know how much it happens here, but in Mississippi, sometimes when we get to a point where the workers believe that it's not going to work and we're pursuing relatives and fictive kid for placement, and we put them with the relative or fictive kid, often it just kind of gets dropped then. And those kids that are put in relative placement don't enjoy the same rights and scrutiny that kids that are in foster placement do. And I just personally, this is my personal opinion, I think that's wrong. I think the kids that are relative placement have the same right to their family, their mommy and their daddy as the kids in foster placement. They just happen to be in a better situation because they're with relatives. But that doesn't mean that necessarily mean that should be their final placement. The relatives should be cared for them, and CPS should be doing as hard a job working on getting those kids back to their families as they are the foster kids. Now I know the money's not there. I know that's not the reason for it. But the reason for it is those kids deserve the same rights as foster children. So I want to impress upon you that please Don't forget about the kids you put in road replacement. They have the right to their mommy and daddy too, as well. Okay. Has the agency informed about the available services, but more so has the agency, has she helped them get to those, or he helped them get to those services? What other services are most likely to work in the situation? Has the family been given an opportunity to say, hey, I think this might be something I need. Can you help me arrange this service? Is there a means being provided to review the agency's actions in this case, their own failure to provide services to the family? Is there anything in place that will fulfill that? Okay. And then develop that appropriate case plan. Have they developed an appropriate case plan that meets the reasons for why the removal took place in the first place? And then the last one down there, visitation again, I can't harp on that more. The visitation element is critical, and the court has to make certain that reasonable visitation is taking place in these cases. Then we know going on past the reunification, if we're going to some alternative type of placement for the child, that the permanency hearings are critical. And again, I suggest that you do them more regularly than annually. Okay. Did they conduct a thorough investigation? Look at that. Did they articulate when they were asking for removal? Did the social worker articulate the threat as immediate, significant, and clearly observable? Did they articulate vulnerability or protective factors to the court when they were asking for removal? What interventions did they consider? Again, did they bring in a parent, a sister, a brother, fictive kid to help the family? And then were they able to articulate the specific harm that might come to a child if the child was able to remain, was made to remain in the home as contrary to the child? Consider all risk mitigation. Again, we talked about this already. Seek short-term safety and ask for an expedited hearing. It's not about trying to solve all the problems at that first hearing. It's about getting to the next hearing and working at that next hearing toward moving on to the hearing after that. Family time is critical. And then a couple of questions that I think the court needs to ask in every case, every time the family comes before the court. First one is there any reason why the child cannot go home today? Simple question to the social worker. If the social worker can't answer that question, more than likely the answer is no, there's no reason why the child can't go home today. And the child should go home in that situation. The second one is even more important, I believe. Because you see, once we remove a child from the home, we tend to put a higher standard on that family that they must meet before we put the child back. We just kind of say, okay, you got to do this, 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 and then we'll return the child to you. But that's not the standard. That should never be the standard. That's the standard. Social worker, if you came up with this family and its condition right now, as it is right now, haven't been improved by you up to this point, and the child was with them in that home, would you remove the child? If their answer is no, the child should go home. It shouldn't be held, that family should not be held to a higher standard than we hold any family when we're making the determination of whether to remove it or not. Okay, there's the question that was asked earlier. What can courts and court staff do when there are not adequate services in the community to assess the needs? Okay, this is the second issue. The courts primarily what we do in Mississippi, I've been doing in Mississippi over the last 3 years, is developing community collaboratives that meet on a regular basis and The first thing they do is assess the needs in the community, identify the gaps, identify what they have. It's amazing when you pull all these shareholders together. It's amazing, for the first time, people find out that services are available they never knew were available. Because we all live in silos all over the place. You pull them at one table and you start talking about identifying a gap in service. Well, this is a gap in service. No, we handle that. We can do that. So you're able to coordinate services throughout that collaborative. You can put together a comprehensive plan for prevention and reunification services to meet the gaps in your area. If those gaps happen, just like that judge up in Alaska, he identified a gap. And that gap was they needed DNA treatment. And what did he do? With his collaboratives, the department and the government filled that gap. Yeah. Is it reasonable if it cannot be fulfilled locally? This may not be as big a problem for you guys as it is for us. That's a question probably, we've got 82 counties in Mississippi and probably 60 of them ask that question every day. And my position is no, it's not reasonable. In today's world, we can find a way to provide those services. You know, for many years, I told you I was in Southwest Mississippi, and we built a pretty robust system in our area. But I drive at 11 miles north of my house. I crossed an imaginary line. It was like going from the first world into the third world, as far as services are concerned. Justice by geography cannot be tolerated. It should not be tolerated, ever. And that's when you make that no reasonable efforts finding, when they do not do what they need to do in those services. Were the necessary services available in the community, and if not, was it reasonable if they were not? Talking about the missing or inadequate service that goes on for having to wait 3 or 4 months to get to a service, that's an inadequate service. If we're talking about a mental health need, or we're talking about a DNA need, is there a long waiting line that you have to wait? What can we do to mitigate that? The court needs to press the agency needs to press agency heads, other divisions of the government on what can we do to meet this particular need. And what about when other agencies cause the problem? Let's say, for instance, you have a person that has done everything he can do to be involved in his child's life, but he has to go, and part of what he had to do was getting right with the law, and he has to go to jail, and he goes to jail, but he can't get out for 5 years, or at least he gets a 5-year term. He may get out in 3 years, and he's serving his 2nd year, but they won't let him have any services, because that's DOC policy. Is that reasonable? If you tell CPS, well, that's not reasonable. He should be getting those services, so he'll be ready to take on his responsibilities as a parent when he gets out. They said, well, Judge, we can't do anything about it. That's DOC policy. Well, Judge, last time I checked, CPS and DOC were all part of the executive branch, right? And I think there's a point where you say, all right, CPS, what are you doing to get DOC to change their policy? And let's bring some DOC people to court to determine what is the real reason why you're not doing this. And if it's reasonable, then it's reasonable. If it's not, then there's a finding there. And I promise you, if this money starts getting lost because DOC has an unreasonable policy, I bet it becomes reasonable pretty quick at the end of the day. Okay. Be aware of your permanency processes. One of the biggest things I've been dealing with over the past several months is removing the obstacles to children actually getting to adoption. Getting rid of plowing through all the weeds so that we can accomplish the adoption itself. So be aware of all of those things. Why not the gold standard? Make the equivalent of active efforts, especially early on. Hold the agency accountable and demonstrate a true sense of urgency to get this done as a court. Demonstrate a true sense of urgency to get this done. What does the court do when the agency hasn't met its burden? Of course, they can make the no reasonable reference finding. I have another suggestion. And that other suggestion is that maybe you leave your case open, continue it for a month or so, identify the issues to the department of what may cause you to make a no reasonable efforts findings, and give the department a reasonable period of time to cure it. And if they cure it, you come back and hold their feet to the fire, then you make your reasonable efforts finding and you go on with it and everybody's happy. If they fail, then you make your no reasonable efforts finding and someone else will have to deal with that down the line as far as putting together.
Oh, yeah, got it.
Yeah. All right, I promise you, if you follow this, social worker practice will improve, period. It will improve. If you're willing to meet regularly with agency workers and supervisors to help train them, that will improve the process. Agency and local officials will assist in bringing the much needed resources to your community when you hold them accountable. The court must let participants know that the judge is paying careful attention to the reasonable efforts issue. The court does this, the practice will improve, children and families will be better served. Judges play a critical role. Juvenile court judges must be leaders in their community. We're kind of like the triage center in the court. We're there, we deal with families who are hurting all the time. And we're responsible to put salve on that hurt. We're the community's most important voices for the at-risk kids. We convene the community around them. We bring the agencies together. We show them what the best practices are. And we must learn of those best practices and we must implement them for the benefit of the children. Remember Judge Edwards, the guy that wrote the book, talked about, he said this about 25 years ago. By failing to take the act seriously and exercise scrutiny over the social services agency delivery process, the judge abrogates judicial responsibility. The judge becomes part of the problem and becomes useless for the purposes of the law. It can result in a lack of accountability by the social services system and wholesale government neglect. Children, pretty doggone power. Remember, it's always about this guy. It's always about him. Children can't wait. They need permanency, hopefully with their own parents. They need to be safe and nurturing place to live. Reasonable efforts is the key to that. And courts and everybody in the system here in the agency play a major role in getting this done. Okay. That concludes. Any questions from anybody?
All right. Sorry, go ahead. Sorry.
Okay, so question?
What about no reasonable effort findings that don't relate to